Good afternoon, or good morning, depending on where and when you are viewing this. Thank you for joining our monthly webinar from the Labor and Employment team at Brooks Pierce, with our focus this month on enforcement trends from the Equal Employment Opportunity Commission, or EEOC, the main agency responsible for enforcement of federal anti-discrimination laws. Our goal in this hour is twofold. First, to alert you to an even more active role from the EEOC in policing workplace discrimination, as evidenced by the EEOC's enforcement data on investigation and litigation, the EEOC's new leadership priorities and resources, and our observations from representing employers in this field, from pre-charge to claim resolution. Second, to highlight strategies to avoid, mitigate, and when necessary, resolve discrimination claims in an era of heightened EEOC enforcement. This presentation is approved for SHRM credit, with the activity ID for credit listed at the end of the presentation, so stick around. Next slide, Kemper. My name is DJ O'Brien, and joining me is Kemper Patton. Kemper and I represent employers in North Carolina and beyond in handling myriad workplace legal challenges they face, including discrimination and retaliation claims. You can find more information about us and our employment team at Brooks Pierce at the Brooks Pierce website. Additionally, we'd love to hear from you. Our contact information is listed here. And during this presentation, you can ask us questions by using the chat function on your screen below. If we can't answer the questions in this hour, which we would try to do at the end of our remarks, we'll reach out offline. Please do not include confidential information in that chat. And relatedly, in our next slide, let me provide the all-important disclaimer, which is while we would love to hear from you and confer with you about your organization's specific legal needs, this webinar in no way is intended to be a substitute for legal advice. It's offered for educational purposes. So next slide is our topics for today, with 5 topics we're going to cover. 2 quick refresher stops to review the life cycle of an EEOC charge and an overview of EEOC enforcement. Next on our roadmap will be 2 longer stops to review recent changes in discrimination laws and new trends in EEOC enforcement. And then finally, we conclude with a stop on how employers can mitigate and avoid claims of workplace discrimination. With that overview, let me turn it over to Kemper to take the wheel.
Thank you, DJ. So following up on what DJ said, really the big focus of today's presentation is to go through the recent updates in employment discrimination laws and talk about the trends in EEOC enforcement. But before we want to do that, of course, we want to give you a primer of the EEOC itself, how the process of discrimination charges works, and what forms of discrimination may be covered. So with that said, we're going to start with the life cycle of an EEOC charge. So from the employer's perspective, the EEOC charge process really begins with the receipt of the charge itself, which is typically done by either email or mail, just depending on how the charge was actually processed. There may be times you're aware of it in advance due to maybe the employee or the employee's attorney informing you of it, but typically you're first going to learn about it through an email or a mail charge. As you see right here, we have an image of a notice of a charge of discrimination. This is just something taken from the EEOC's website, and it provides you with various information about what the charge alleges and how you can access the EEOC's respondent portal. The respondent portal is where you will access further information for the remainder of the investigation. It's where you can get access to the charge as well. And it's where you'll be able to immediately be given the opportunity to engage in the EEOC's internal mediation procedures. And as I get to the next slide, you'll see an image of the respondent portal for you to take a look at. But for the EEOC's mediation process, this is really an opportunity where both parties are going to be given the option to mediate before the EEOC's, I say, neutral mediators. Mediation before the EEOC is not mandatory, but in my experience, the EEOC will push for it, and it's typically something charging parties will opt for. And it's usually a decision of principle versus practical, right? It's a business decision as to do I want to try to get this over with quickly rather than engage in something that could last perhaps several years. On the other hand, it's as a principal matter, employers are oftentimes going to consider whether or not they want to set a precedent that they might be willing to handle these charges through mediation. So it really comes down to a business decision on the side of the employer. So next, I want to discuss actually litigating an EEOC charge. Now, as I said, you can see here an image of the respondent portal. It's very similar to an online version of the notice of the charge, right? You see information concerning the charge allegations, but you also see where you can select to do mediation. You see where you have the contact information for your EEOC investigator or your EEOC contact. And you find out information about potentially your next steps, which is going to be the employer's statement of position. Typically, when you choose not to mediate, that's going to be the very next thing that's going to be required of an employer, and it's going to usually be due within a few weeks after the charge is filed. The position statement's really the employer's response to the charge. It requires a lot of caution to prepare. Charging parties are oftentimes given access to a copy of the position statement, as well as supporting documentation that's provided with it. So it can be a delicate balance preparing a persuasive statement that doesn't necessarily provide too much information that's not necessary at an early stage of the process. After the position statement is filed, you can usually expect that the EEOC will follow up with a request for information, if not multiple requests for information. It typically occurs several months after the statement of position is filed. And as the years gone on, they've become pretty common to the point now where they are pretty much expected. Typically, the information requested is going to come in a mix of two categories. It's going to be organizational information about the employer. It might be employee lists, an organizational chart, things like that. But it also might be, on the other hand, things that are charge specific, right? The employee's personnel files, maybe disciplinary records, things like that, if that's relevant. Similar files for other employees as well. And much like the statement of position, it is important to respond to that in the right way, right? It's something that the employee or the charging party is oftentimes going to get their hands on. So you have to know how to handle responding to those requests the right way. After a request for information, there may or may not be on-site interviews or remote interviews. This is where the EEOC will conduct interviews and perhaps be on company premises to talk with employees about maybe the allegations in the charge or other things that they're interested in. It's really important at this stage to ensure that representation is involved, because attorneys are oftentimes allowed to sit in on these interviews and can ensure that the EEOC doesn't overstep its authority or maybe even inquire into confidential information, which can happen from time to time. After the EEOC has finished conducting its investigation, the EEOC will come to a conclusion of either cause or no cause. No cause means that the EEOC has effectively concluded its investigation and that there's going to be it's not going to continue pursuing the charge further. It's not necessarily stating that the EEOC thinks there's absolutely no merit to the charge, but they're not going to pursue it any further. And so they'll be issuing a letter to the employee that allows the employee or the charging party to initiate litigation within 90 days. A cause finding means that the EEOC has found reasonable cause to believe that the alleged discrimination has occurred. And similar to a no cause finding, it doesn't necessarily mean that the employer has in fact discriminated or retaliated or something like that, but it effectively means that the EEOC believes the allegations are worth pursuing beyond their investigation. If there is a cause finding, the EEOC is statutorily required to attempt to resolve the matter through what is called conciliation. Conciliation is a sort of an offshoot of mediation, a bit more of an adverse form of mediation, where the EEOC will provide typically terms for an agreement to resolve the charge. There's oftentimes certain terms in there that the EEOC is allowed to make a press release about what has happened. They will They will require the employer to maybe put up posters, things like that, explaining the situation in their workplace, as well, of course, as providing any sort of financial recuperation for or remuneration for the charging party. And after that agreement is provided, it will typically there will typically be some sort of meeting between the EEOC, the charging party, and the employer to discuss the final resolution of the case. This is not a mandatory process, but it is oftentimes something worth considering given the fact that the EEOC may have the opportunity to pursue litigation if conciliation is not successful, or the charging party is going to be even more motivated perhaps to get an attorney. Now, with that said, now that we've kind of gone through the general process of an EEOC charge, I want to just very briefly touch on the statutes that the EEOC enforces and the types of discrimination and some of the variations of discrimination that are common when it comes to handling an EEOC charge. So just briefly, I've listed some statutes here. These are the statutes that the EEOC covers: the Title VII Age Discrimination and Employment Act, Americans with Disabilities Act, Equal Pay Act, Rehabilitation Act, Genetic Information on Discrimination Act, and the most recent Pregnant Workers Fairness Act. Each of these protects against discrimination on a particular basis. As you see with Title VII, the bases listed there: age, disability, equal pay. Each of these provides some sort of protection. The EEOC oversees enforcement of those acts. Retaliation is a slightly different beast, as I'm sure most of you are probably aware of. It involves the retaliating against an employee for taking lawfully protected action or for engaging in lawfully protected activity. That's going to be opposition to unlawful discrimination, as well as participation in an employment discrimination investigation. So think an employee deciding that they believe a order from their employer is unlawful and choosing not to obey that order. The employee can't be disciplined for that because that is the employee opposing what the employee believes is unlawful discriminatory behavior. So that's really what retaliation covers, and it's really one of the most prevalent things we see when it comes to EEOC charges. Next, I also want to discuss harassment briefly. Harassment is a form of discrimination that is based on somebody's protected category that we discussed earlier, right? Race, color, national origin, sex, age, things like that. Harassment differs from the typical form of discrimination that doesn't necessarily involve an adverse employment action, right? It doesn't involve necessarily a demotion, suspension, or even termination. But it involves a fundamental change in the conditions of employment, where the conditions become abusive in some way connected to an employee's protected category. Harassment is a really harassment in particular is a really big concern for the EEOC. As we'll discuss later, the EEOC has recently finalized guidance on combating workplace harassment. It's something that's been in the works for quite some time. And much like retaliation, it's something that we see quite often when it comes to EEOC charges. And finally, just to briefly touch on which employers and employees are covered by the EEOC's statutory enforcement power. That's primarily going to depend on what statute is in question. Title VII, it's going to cover employers with 15 or more employees. I won't go through everything here, but you can see how it's just going to depend primarily on how many employees an employer has, except for the EPA, which is going to cover almost all employees, in the Rehabilitation Act, which is going to cover federal contractors and subcontractors. Now, with that, I'm going to swap it back to DJ to discuss updates in employment discrimination laws.
Thank you, Kemper. And before I turn to those recent updates, I just want to briefly mention, piggybacking on what Kemper said, that framework may be familiar to you. It largely has stayed the same all the years I've been practicing with respect to how the EEOC goes about investigating things. However, we're seeing an uptick in resources. And so right out of the gate, sometimes you will see a request for information, whereas previously you might get a charge, file a response, and not hear anything for a while. One thing that really hasn't changed, at least not from my perspective and seeing these charges come across my desk, is the time frame for EEOC resolving these. That is to say, despite having additional resources and more enforcement efforts, the time frame for these being resolved are still taking a long time. So you may get a request for information early on, but then for another year or so after initial flurry of activity, you may not get any responses. These things still drag out quite a bit. Whether that benefits the employer or the employee, people can debate, but these things do last a while. But that time frame may stay the same, but the enforcement is certainly going to continue an uptick. I want to talk about 3 recent updates in employment discrimination laws. One will be the Pregnant Workers Fairness Act, 3 recent Supreme Court cases that don't necessarily touch directly on private lawsuits by employees, but you'll be hearing your employees talking about them and believing they infect the workplace. In some cases, they do. And then third, as Kemper mentioned, the EEOC's finalized workplace harassment guidance. With that, let me talk about the PWFA on our first slide in this category. As Kemper said, this is very new. It was effective just a year ago. It passed Congress in late 2022. It was attached to one of those omnibus appropriations bill. It is designed to give pregnant workers additional rights. It is not the case that before June 2023 that employers could discriminate against employees who were pregnant. For decades, pregnant workers have had the right not to be discriminated against due to limitations imposed by pregnancy. But they didn't necessarily have an independent right to workplace accommodations that are specifically for pregnancy, and that has changed. The PWFA, it requires covered entities to reasonably accommodate qualified employees and applicants with a known limitation. And that's related to, quote, pregnancy, childbirth, or related medical conditions. And that's unless doing so, and if it would impose an undue hardship. Most of you are probably very familiar with the concept of undue hardship. I say familiar with it, that you've heard the phrase, you've gone through the interactive process. What actually constitutes an undue hardship is extremely fact-specific and difficult to predict. And for better or worse, that framework for evaluating limitations, reasonable accommodations, and unfair hardships, undue hardships, has been adopted for the PWFA. So it is modeled on the framework of the ADA. And the PWFA, though, does track Title VII of the Civil Rights Act of 1964 in applying to private employers with 15 or more employees. Sometimes that analysis, by the way, if you're covered or not, can be more complex than just looking at who the W-2 employer is. There can be other rules that bring in kind of affiliated organizations to make the workplace bigger than, say, for example, 15 employees, and it applies. So this is a new category that employers are going to have to grapple with, and it's very, very new. With the next slide, I want to talk about what the EEOC has done in response to this law passing. Obviously, Schoolhouse Rock taught us about how a bill becomes a law, and of course, the EEOC as a implementing agency has a lot of power with respect to how this is going to be interpreted and, of course, enforced. The EEOC issued its final rule on April 19th. It'll become effective June 18th, so we're a matter of weeks away when this will become effective after a notice and comment period. Now, the act that was passed by Congress and signed into law did not define the phrase pregnancy, childbirth, or related medical conditions. Now, but the EEOC has included a definition in its final rule, and that definition includes pregnancy, past pregnancy, potential pregnancy, lactation, which includes breastfeeding and pumping, use of birth control, menstruation, infertility, and fertility treatments, miscarriage, stillbirth, or having or choosing not to have an abortion, among other conditions. So it's quite broad in terms of deciding what is related to pregnancy as a related medical condition. Just recently, several states, about 19 or 20, have challenged in litigation some of the final rules, the final rule, particularly with respect to abortion, that could impact how the effective date of the final rule is implemented. We'll have to wait and see. But as of right now, this is guidance, regulations that employers are going to need to be grappling with. And again, it grabs the undue burden, reasonable accommodation language from the ADA. Let's go to the third slide, Kemper. This is talking about the EEOC guidance in terms of what is needed for an employee to request an accommodation. Now, an eligible employee with those conditions is entitled only to an accommodation or accommodations that are deemed reasonable. The PWFA, again, draws on the ADA to define accommodation as a change in the work environment or in the way in which tasks are performed. So hopefully by now you're familiar with the ADA process. You've gone through it. You know there's not always clear guidelines. This is going to be even more of a gray area because while it's adopting that framework and there's going to be examples to follow, we're talking about new regulations from a new law. The regulations try to be helpful by including examples of reasonable accommodations. Now, not all of these accommodations would necessarily be per se reasonable, nor would certain accommodations be per se unreasonable. It's going to be fact specific, but the guidance from the EEOC does provide what may be considered a reasonable accommodation. And they are listed out here: sitting, standing, kind of the obvious ones for a pregnant person or a person with a related medical condition. Equipment, temporarily suspending one or more essential functions, adjusting or modifying examinations or policies. So while not every reasonable accommodation is defined, while there's not necessarily a safe harbor saying if you adopt this particular accommodation, you're covered, they do try to give some examples. I also want to talk about some recent Supreme Court cases that have come out. This is not a continuing legal education seminar for lawyers, so I don't intend for it to be, but I want to mention these cases from 2023 that were heavily in the news and that we're seeing employees cite as potentially providing new rights. The Harvard case dealt with the unconstitutionality for colleges and universities to consider race as a factor in the admissions process. By its terms, it has a limited scope. The Harvard decision should not necessarily have a direct legal impact on private employers. However, it's being watched to see if there's going to be an increase in legal challenges to employment decisions and DEI initiatives, meaning race-conscious decisions. So we expect that may come up quite a bit. Groff versus DeJoy, this dealt with where the court held that to deny a religious accommodation, an employer must show that the burden of that accommodation is, quote, substantial in the overall context of an employer's business. This has been interpreted, obviously, as giving potentially greater rights for religious freedoms, religious accommodations in the workplace. Little different, though, is the 303 creative case, and that was where the court held that forcing a website designer to create websites expressing views inconsistent with her own religious beliefs would violate the free speech clause of the First Amendment. So that's a First Amendment case, not a religious freedom case. And it raises questions with respect to a business's ability, to deny services to certain customers based on free speech protections under the First Amendment. You could see that being interpreted by employees as extending rights to them. Now, employees can't bring direct First Amendment claims usually against private employers. You could see an uptick in employees seeking more religious exemptions because of this decision. Also want to talk thirdly with respect to new trends and guidance on the EEOC's finalized workplace harassment guidance. Again, this is very new with an effective date of just last month, April 29th. This is the first update to anti-harassment guidelines in 25 years. It's been political football for decades, and it has taken effect immediately. And this guidance focuses on legal analysis of harassment and the standards for imposing employer liability for harassment, based on the statutes that Kemper cited that are enforced by the EEOC. The EEOC has stressed that employers are responsible for preventing harassment. So it's looking at what you have done on the front end to prevent harassment, not just how you responded to it. That's always been the case, but here there's going to be a heightened burden, I think, on employers because you're certainly on notice with this guidance. And states that Title VII prohibits harassment based on gender identity, which is, of course, something very, very new that has been in the news. When I say new, of course, I'm talking about very much publicly discussed and available. And that includes intentional misgendering and restrictions on bathroom access. Next slide, Kemper. The guidance does not define, it doesn't just define harassment, but it provides examples of potentially violative conduct. And it talks about what the complaint process would be, what it would be an effective training process, procedures and training available designed to prevent and allow for reporting of harassment, to make sure supervisors are actually reporting harassment as opposed to just receiving it and doing nothing about it. It also talks about confidentiality and how to go about ensuring that employees have the ability to feel secure if they report something, that they'll be able to have it addressed. Next slide, Kemper. We're in 2024. As I said, the guidelines have not been updated until now for 25 years. So this is a new focus on technology's role in harassment. And this guidance explains that Title VII prohibits harassment in virtual work environments. That can be work-related communication systems such as Zooms, text, other types of environments. And it provides examples of where harassment can occur, which is not just your stereotypical water cooler comments, but also things that happen which you may consider to be offsite. Although I think if it's an employer Zoom meeting, you probably are not considering that to be offsite. At least I hope you're not. So it has good guidance there for what's happening in the workplace in the virtual environment. Next slide, Kemper. As I said, it also has talked about religious expression. I just talked about potentially Supreme Court decisions creating a greater right or perceived right for religious expression. However, that's got to be balanced when you get an accommodation request for religious reasons, that you're not creating a hostile work environment. You can be in a rock and a hard place by trying to do the right thing by accommodating a religious expression request. You've got to make sure that you got to consider the effect on other workers. Also, there's discussion regarding sexual orientation, as I mentioned, and gender identity. And so my takeaway from this guidance is that harassing conduct is now being designed to be proactively obligations on employers to make sure that it does not happen. There are new specific things that are hot topics that are coming up. Importantly, harassing conduct can include repeated and intentional misgendering or denial of access to bathroom consistent with an employee's gender identity. These are issues that are now going into the workplace just as they are around all of the environment. Employers will be dealing with it because the EEOC at a minimum, we'll be taking a look at these issues. With that, let me turn it back over to Kemper.
Thank you, DJ. So now that we have discussed updates and trends in employment discrimination laws, as well as the previously enforced employment discrimination laws, we want to discuss updates and trends in how the EEOC is looking to enforce these laws. So the main thing I'll be discussing here is the EEOC's recent strategic enforcement plan that was released this past fall. Before I get to that, though, I do want to briefly discuss just some recent statistics that we recently received from the EEOC. These are from the EEOC's 2023 annual report, which was released in February 2024. And you can see everything here. I won't necessarily go into all of the numbers, but the really big takeaway here is that inquiries with the EEOC are going up. the EEOC's enforcement proceedings, and how many lawsuits it is filing are increasing. So really overall activity from the EEOC is just increasing. And you see, of course, this number at the bottom, achieving favorable results in 91% of all federal district court resolutions. That would, of course, be occurring after the EEOC has completed its investigation. Conciliation was not successful, and the EEOC decided to file suit on behalf of the employee or the charging party. The EEOC typically has very favorable, it typically does very well in federal district court cases, but it's always something to note to see a number as high as 91%. So just being aware of the EEOC's increased activity as well as that high favorable result is definitely something to keep aware of going forward. But now I want to really focus primarily on the EEOC's 2024 to 2028 strategic enforcement plan. This was released in September of last year. Generally speaking, the EEOC's strategic enforcement plans are meant to forecast its focuses and its goals for the upcoming fiscal years. The most recent one was for the fiscal years 2022 to 2026. And the new one is an updated version of that previous strategic enforcement plan. But what's really worth noting here is that the previous strategic enforcement plan really focused on procedure over substance. It was concerned with increasing resolutions through conciliations and increasing resolutions during the litigation process. It was focused on improving the quality of its investigations, the quality of its intake services, providing more access to the information it provided, and making more effective use of its resources, doing a better job providing guidance and training to through its local offices. So the previous strategic enforcement plan really focused heavily on the procedure side of the EEOC's work. But as you'll see here, and as we'll discuss in a little bit more detail, the new strategic enforcement plan really focuses a lot more on the substantive concerns rather than the procedural concerns. So, like I said, as we'll discuss, it does not focus as much on conciliations, investigations, intake services, and things like that, as much as it does targets of discrimination, certain vulnerable and underserved or underrepresented workers. It focuses really heavily on emerging and developing issues in the workplace. The rise in workplace technology, as DJ has already mentioned, is a great example of that, as well as preventing and remedying systemic harassment. And of course, to add one more procedural concern, providing more access to the legal system was mentioned heavily in this new strategic enforcement plan as well. So we're going to touch on a lot of these issues in particular, but what you're going to notice is that there's a lot of overlap here. Particularly, you see emerging and developing issues as well as the rise in technology. Those overlap quite a bit. Targets of discrimination as well as vulnerable and underserved workers will overlap a lot, but there's particular reasons for a lot of these targets or the focuses in these in the new strategic enforcement plan. So to start, I'll briefly discuss some of the anti-discrimination targets in the new strategic enforcement plan. So the strategic enforcement plan did not specifically mention particular targets, but the press release that came along with it did mention these in particular. So I think it's worth noting. It mentioned the prevalence of discrimination, bias, and hate directed at religious minorities. The of course examples, particularly with right now, would be anti-Semitism and Islamophobia, racial and ethnic groups, as well as LGBTQI plus individuals. So, like I said, the EEOC's strategic enforcement plan did not specifically address these as its main anti-discrimination targets, but they were really prevalent throughout the strategic enforcement plan. And they were mentioned in the EEOC's press release. So I think it's something worth keeping in mind as the EEOC focuses on these groups for their upcoming fiscal years. Next, we have the EEOC's focus on what it calls vulnerable and underserved workers. This would run, like I said, hand in hand with their anti-discrimination targets, right? This category is going to include employees that may be unaware of their rights or under employment discrimination laws. Maybe they were reluctant or simply unable to exercise their protected rights, or they simply have been underserved by anti-discrimination protections. So there's a list here, and of course, you see the LGBTQ plus, for example, is something that's been reiterated here as a focus. But there's also an interesting focus here on things like individuals with intellectual and developmental disabilities, right? There's a noticeable focus on employees that may not have knowledge of the type of protections they have and have been taken advantage of. So the EEOC has said that that their district offices are going to try to identify groups that may fall into these categories that are in their area for what they said is, they called it focused attention. And they provided an example, which I think is potentially helpful to conceptualize this, which would be, for example, a Pacific Northwest EEOC district office may in particular be focused on Alaskan natives, for example. And if you maybe wanted to show a difference between that and how it might apply here, in the Southeast, it may apply to focus more on low-wage agricultural workers. So you see how the EEOC is focusing on particular groups depending on where their district offices might be, and in particular when those groups consist of vulnerable, underserved workers. So next, the EEOC's focused on what it calls emerging and developing issues. This is really a pretty big catch-all to just address or to just try to capture how the EEOC is trying to ensure workplace protections extend to all sorts of different groups of people as new issues in the world may develop. So the examples here would be, for example, pregnant employees with pregnancy-related conditions, right? That arises out of the Pregnant Workers Fairness Act that we've already talked about. Long-term effects of COVID-19, of course, coming out of the pandemic. How are certain employees being treated coming out of the pandemic if they maybe have certain lasting impacts from COVID-19? Discrimination from the backlash or discrimination arising from the backlash involving local, national, and international events. Speaking of anti-Semitism, Islamophobia, that's a good example of the overlap here where the EEOC is focusing on emerging issues. And also the increase in workplace technology. DJ has already discussed this as it arises out of the workplace harassment guidance. And as we'll discuss later, I mean, the increase in technology in the workplace is a very significant concern, particularly with how the increases in technology in the workplace might pertain to making personnel decisions and things like that. So going forward, I think this is going to be something that is in a way a catch-all for the EEOC to focus their concerns on different issues as they arise. Next, I want to discuss the EEOC's underrepresentation or the EEOC's focus on underrepresentation of certain workers in industries and in certain industries and sectors. Again, this overlaps in a sense with the vulnerable and underserved workers, but there's a different emphasis on this one, if you will. This one really emphasizes the providing protections to employees such as women and employees of color that may not be represented in certain industries and in certain sectors. The example that is given is perhaps women in areas such as engineering or construction. It's maybe worth noting that the focus here has specifically been on women and workers of color. The EEOC has really narrowed its scope to those particular groups and certain industries and sectors that they have not been represented in the past. Next, the next focus of the EEOC's strategic enforcement plan, as we discussed already, would be the increase in the use of technology, particularly when it comes to making personnel decisions and making recruitment decisions. This is really something you could have a full webinar on. And as we've already discussed, it's prevalent when it comes to workplace harassment, and it's prevalent here when it comes to making certain employment and personnel based decisions. The elephant in the room here is artificial intelligence. Artificial intelligence tools are oftentimes used in making sort of recruitment decisions, and they can be used in making personnel-based decisions. But the dangerous aspect of this is that if the AI tool is having some sort of discriminatory impact in how it's making decisions, the employer could be liable for that. The employer cannot feign ignorance about how an AI tool may be assisting the employer in making personnel decisions. If it turns out that the tool is having a discriminatory impact, so the real concern here would be the ADA, the ADEA, and the example I've used before. Maybe something like blindness, for example. Blindness is an ADA, is consistently considered to be an ADA disability. Now, say you have an artificial intelligence tool that is tracking eye contact during an interview, something like that. It may be challenging for somebody who is blind to be able to do that for obvious reasons. So that's sort of an example of how an artificial intelligence tool may make a decision about an applicant that you are unaware is made based on an applicant's disability, for example. So as AI becomes more prevalent in the workplace, it's going to be something, it's going to be more and more of a focus of the EEOC going forward. Next, again, as I mentioned, really for a more procedural concern rather than a substantive concern, the EEOC has mentioned that it is focusing on access to the legal system. And this is something that has been consistent across other agencies. And it's consistent dating back, in particular towards the beginning, I believe, of last year when the Speak Out Act was passed. There are steadily being more and more protections for employees to have the opportunity to speak up concerning issues in the workplace without being held back by maybe broad non-disclosure agreements, broad waivers, or non-disparagement agreements, things like that, as well as arbitration agreements as well. And on the employer side, not necessarily the employee side, but on the employer side, the EEOC is going to be focusing on employers and making sure that employers are keeping good records as they're required to do. Because the idea that arises out of this is that if an employer does not keep the proper records to allow the EEOC to conduct the investigations it needs to do, that's going to be seen, or that could be seen as the employer making an effort to limit the EEOC's ability to conduct its investigations and enforcement proceedings as it is required to do. And then last, this is something that it's pretty consistent across strategic enforcement plans. It's something you're going to see in just about every single time the EEOC discusses its goals going forward. The EEOC is of course concerned with preventing and remedying systemic harassment. The EEOC noted in the strategic enforcement plan that it is continuing to see as I said, widespread patterns and practices of harassment in the workplace, including both in-person harassment and online harassment. I think that's going to partially come out of that partially connects to, as we said, with the workplace harassment guidance focusing on online conduct as well as in-person conduct. The EEOC has noted the widespread pattern and practice of harassment still in the workplace and the increase in harassment claims in charges of discrimination. So that's certainly going to be a focus of the EEOC going forward. And with that, I'm going to turn it back to DJ to discuss processes for mitigating discrimination claims.
Thank you, Kemper. And I also want to, before we jump into some of those mitigation workforce discrimination claims, we have a question in the chat box asking about our perspective on recent claims brought by white males. And I just want to address that because it does touch on my earlier point regarding the Harvard Supreme Court decision from last year, which is related to affirmative action not being permissible under the Constitution with respect to both public and private universities. My comment was it will be cited as potentially a basis on which there should not be discrimination against white males, white individuals, the concept of not having reverse discrimination occur. There was a Starbucks decision from a couple of years ago that predated the Supreme Court decision related to a white manager who believed she was terminated because of a focus on public relations that Starbucks was dealing with. My only comment would be that you are likely to see more claims brought by white individuals, white workers, for the concept of discrimination being reverse discrimination to the extent that a DEI program or another race-conscious decision is seen as being discrimination against a single applicant. That's not at all to say that DEI programs should not be instituted, not at all. They have still the goal that's supported by the EEOC and federal statutes of diversifying workforces. However, I do think you'll see a rise in those type of claims as this gets sorted out. I do want to talk about mitigating workforce discrimination claims. And these are hopefully things you're already considering doing, you've been doing for years, but are more and more important than ever. Kimber, if you could advance to the next slide. Obviously, employee handbooks are very, very key. The first thing that the EEOC may ask for with respect to insurance it's investigating is a copy of their policies. It wants to see that you have policies. It wants to see if you're following those policies. It wants to see if they've been updated. Sometimes they will have a problem specifically with the policy and not with how it's actually implemented, meaning you've got what you consider to be a non-meritorious charge filed by somebody, and you believe very strongly that you can beat that charge and prove that there was no discrimination, no retaliation, no harassment, and yet the policy is inadequate, and they're going to have questions about that. And that's certainly the case if the National Labor Relations Board is an entity that's investigating it, because their whole purpose in a lot of ways is to look at the overall policies of an organization and apply not just to the complaining party. So updating those employee handbooks is very, very key, especially now with new guidance from the EEOC. They want to make sure that you're paying attention to what they've put out. Harassment policies, EEOC policies, making sure that your handbooks, your policies are reflecting the very most recent guidance with respect to pregnant employees and LGBTQI employees. Religious accommodation policies, and to make sure that your policies, while they are tolerant and respectful of religious beliefs, are not going to go the other way and create environments that could be deemed hostile simply because you're trying to accommodate another individual's request for an accommodation. Next slide, Campbell. You can have a great handbook, a great policy that exists on a shelf or on a database that you're ready to show to the EEOC should they come knocking. However, if you're not training your employees, your managers on these policies, or you're not following them consistent with those great policies in your handbooks, there's going to be issues. Frequently, we see a request from the EEOC, not just for your handbook, your policies. They want to say, where's the evidence that your managers have been trained on these policies? There's different ways, of course, to establish that in terms of records of calendar invites, records of formal training, records of consultants brought in, records internal to individual personnel files to make sure that you can show that employees were trained. And it's not just proving, of course, that you're training people on your anti-harassment, anti-discrimination policies. It's a great way to ensure that you never actually have those claims pop up. Managers are always going to be key. They're going to want to know who's responsible for making decisions with respect to accommodations, with respect to adverse employment decisions, and then specifically, what type of training do that manager have? Were they given the tools they need to make sure that those for whom they're responsible for in managing are up to date on the latest anti-harassment training, anti-discrimination training, and that they've actually heard of the new rights that pregnant workers face. Ignorance of newly passed regulations and laws is not going to be an excuse for discrimination that occurs on your work site. And again, confirming that all the harassment trainings are handled in requirement with those new requirements is very, very key. We understand that not every employee, not every manager enjoys having to take time away from work to sit through training. However, it's absolutely critical, not just that you've got a box to check that they've gone through this, but that they actually are receiving the very latest guidelines. There's some great resources out there, and they should be taken advantage of because the EEOC, among others, is going to expect for you to. Next slide. And then, of course, reviewing your systems in place for making personnel decisions. Kemper mentioned AI or algorithmic tools. This is the Wild West with this stuff out there. People are using it, but we don't know the exact impact. And they have the ability to discriminate. They have the ability to go on the very far end. So you need to know exactly what tools are being used. It's not going to be a defense to say, well, this decision was made by an AI application that I use, so it's not my fault. They're not going to be able to claim, you're not going to be able to claim lack of knowledge for any discrimination that results from these decisions. It's oftentimes organizations are having things go very, very well. They're not thinking about, although HR managers, like lawyers, are often trained to be kind of paranoid about worst case scenarios, but oftentimes it's difficult to foresee having a discrimination claim, having actual harassment occur on your work site. It's not something your organization wants. It's certainly not something they're consciously trying to encourage. And in fact, there is no tolerance for it. But if there's an environment in which you don't have the systems in place, the training in place, the policies in place to show that you're doing what you can to minimize and prevent that, including through the use of new technologies, then you're not going to be able to claim that simply you had a bad manager or your heart was pure, and so therefore you should not be held liable. So review those systems in place. A great way to get into trouble with the EEOC is to have a policy in place that makes a lot of sense, but record evidence displaying that you're not following that policy. Because after putting the policy in, there's not been the follow through to make sure that those safeguards are actually being followed. Next slide, Kemper. And then, of course, consider your region and industry. I talked about this not being a substitute for legal advice. A lot of these employment law questions, especially with new guidance, are very fact specific, and they can be industry specific. There could be industries in which certain workers are underrepresented. I talked briefly about claims by white males, for example. Again, the guidance here is not to say that DEI programs are per se good or bad. They have a lot of worthwhile goals. The EEOC is going to be expecting that you have an appropriate policies in place to make sure that you treat all people equally, and that includes avoiding the effects of discrimination that has a disparate impact, and that can be in certain industries that he believes, with strong evidence to support that belief, that people are unrepresented in those particular industries. And we've listed a few of those out there. Also, there may be regions in which certain employees are vulnerable or underserved. So you've got to consider that context-specific approach. I don't see any other questions in the chat box. We certainly appreciate your time in this webinar. Again, Kemper and I would be happy, as with the whole Brooks Pierce team, to confer with you regarding your specific individual needs. We appreciate your attention for this. We're gonna put up the SHRM credit here in just a second, but for Kemper and I, let me say very, very heartfelt, we appreciate you joining in and listening to our presentation today.